otherwise appropriate, then that's fine. But we're not going to have Mr. Boysen be asked whether or not he agrees with the outcome of determination this court has yet to make today.
Well, I don't think that anybody's asking Mr. Boysen to necessarily agree with the state's argument, but the key thing is obviously that he was informed of what the state's position is on the law, and I think that was abundantly clear from the last hearing that we had. It's in both in writing in the plea agreement. It was said orally. There was no question that the penalty that he was facing was life without parole. So I don't think it's necessary to conduct
no further questions from the state, Your Honor.
From the defense.
So if you want to go proceed with your argument then with regard to sentencing, Mr. Yip.
How does the court wish to proceed as far as what's the state's response to the defense exceptional sentence request?
Well, I mean, typically the state makes a presentation with regard to sentencing. I realize that the state's position is that there's not really much to discuss with regard to that, but you can go either. You can proceed. I don't know if there any of the family members wish to present any testimony or statements in the case or anything like that.
Your Honor, this is a unique situation. With the court's permission, my suggestion is that we not conduct a dash. I think what's really important is that we resolve the
Thank you very much. You may step down.
exceptional sentence is even allowable by law in this case.
Next.
Because if the court rules that it is not, the state's not asking the court to ask Mr. Boysen if he agrees.
Your Honor, we just had a question whether we want to take the morning recess or we want to proceed.
It's now a good time to break.
Now knows
Great. Okay. All right. Sounds good. Could I just ask you, ladies and gentlemen, when you give me questions, if you could leave them on at least half a sheet so that I have some room to write on them, that would be helpful. They do need to be preserved for the record. You'll note that I do that each time you provide questions to me.
Well, why don't you go ahead and present
We'll
your
now
argument
break
then,
for our
Mr.
morning
Conway,
recess.
with
It'll take
regard
about
to,
15 minutes.
sentencing.
Ladies and gentlemen, remember my admonition to you. It's your duty not to discuss any subject of this.
Basically, this case is unique, given the circumstances that existed previous to this point in time. Given the circumstances that existed on October 4th when this plea was entered. At that point in time, and actually since the inception of this case on or about March 21st, Mr. Boysen has been charged under two statutes. He's been charged under 9832030, subsection 1A, and 1095-020, subsection 10. Basically, the list is a list of aggravators that the state can charge from potentially 20 years to life without, and or death. Now, as the court is also aware, there were protracted exchanges between the state and the defense with respect to whether or not we would be submitting a mitigation package, what the package would consist of, and then whether or not they would be seeking special sentencing proceedings. We didn't submit a mitigation package. The state elected, after the fact, not to seek special sentencing proceedings. And that left Mr. Boysen with really no choices under the circumstances. But he has a choice today, and he had a choice when it came to the state's election to charge under two different statutory schemes. Because under 9A, there is another statutory scheme that's devoted to sentencing ranges. And there's actually a statutory scheme for aggravated murder. And I have attached that to our pleadings. And that statutory scheme is life without / death. And that's in what they describe as sentencing grid D for crimes committed after July 24th, 1999. And then it also, beneath that particular caption, reflects a statutory site, and that is RCW 9.94A.5, 9.94A.510. That's obviously the SRA, and the sentencing grid under the SRA. So the problem that we have before the court today is which sentencing grid do we use, whether or not, in fact, life sentence without parole / death penalty, as is otherwise described in sentencing grid D, is something that we can make a request for an exceptional sentence down from. There's nothing in 9A or 9 that prohibits the defendant from making a request for an exceptional sentence downward. This court doesn't want to grant it. That's up to this court. But there's nothing that prohibits him from doing so. If he were charged just under 1095, the arguments are different. And the arguments then, and I think Mr. Yip sent us a copy of Cummings today, the arguments then go to the effect that the only option options are life without or death. The state decides to seek death. All of the cases that the state relies upon went to trial as aggravated murder charges under 1095. There's no mention made anywhere in any of those cases, and Leas, I think it is, Leas, L-E-A-S, doesn't say anything about Alfred pleas to a charge of aggravated murder. They don't say anything about whether or not the defendants ever had a plea. They did not. In Leas and Ortiz, they went to trial on the charge of aggravated murder. So this case is unique and different insofar as its application of facts before the court today are concerned. There are two different sentencing guidelines. Under the rule of lenity, this court is obligated to follow the one that is the least punitive insofar as Mr. Boysen is concerned. There's also other cases. It was interesting in reading Cummings today and going to a couple of other cases. There's another couple of arguments that I wanted to make for the record today. Although they are constitutional magnitude, they can be made at any time, including on appeal, which is likely where we may end up. And that is to say that there's an equal protection argument as well. Under the 14th Amendment to the United States Constitution, in Article 1, under the 14th Amendment to the United States Constitution, and Article 1, Section 12 of the Washington Constitution, if in fact the same behavior can result in different penalties. It's referred to briefly in Hurtado, but more specifically in Sherman, and then after Sherman, a couple of other cases as well, because although they dealt with very minor offenses, if the same offending behavior can be charged in differing ways, one is a felony, say for instance, and one is a misdemeanor, then there's a problem. There's an equal protection problem. Because the state should not have the unfettered discretion basically to determine penalties in this case, which we maintain that they do by virtue of the elections that they have made. This case was charged in the conjunctive, not the disjunctive, not in the alternative, in the conjunctive. So then the question becomes, which statutory framework do we use? It's interesting because I also attached a copy of the scoring sheet. And the scoring sheet says the same thing, for the most part. It says license without parole / death penalty. It does say a person found to be intellectually disabled may in no case be sentenced to death. But there's a scoring sheet. And that particular scoring sheet also refers to 1095, 020, 95, 030. Well, that's kind of fascinating due to the fact that at one point, the state would like to suggest that 1095 is controlling. That's it. That's the only thing controlling, but that's not true. Why would you refer to those statutes in a grid, if you will, or a scoring sheet that below that piece says sentence range? It doesn't say the only sentence. It says sentencing range. Well, if there's a range, then we should be permitted to make a request for an exceptional sentence downward as a departure from that range. The arguments are actually fairly logical, I think. It makes sense under the circumstances. Obviously, I'm sure disagree. There's a range. We're entitled to make a request for an exception to the range. It can't be said that 1095 is controlling, given the fact that the state charged in conjunctive. There's sentencing grids that speak to that particular issue under 9 and 9A. That's a problem in this particular case, and will always be a problem for purposes of future appellate scrutiny. Mr. Boysen's entitled to basically the penalty that's the least punitive under the circumstances by virtue of the rule of lenity. You can't have unfettered discretion to make charging decisions that limit his options as far as sentencing is concerned. They can make discretionary calls when it comes to whether or not they seek the death penalty. And I think that was borne out in Macro and Anderson when the civil defendant was referenced in our pleadings. But that's different than charging decisions. That's completely different. If you want to say or prescribe different penalties for the same offending behavior, that is a problem under case law, under the Washington State Constitution, and under the United States Constitution. And therefore, we're making a request for an exceptional sentence downward because we don't think Mr. Boysen is prohibited from making that request by virtue of the unique circumstances in this case. The state never bothered to address mitigating factors, and so I guess we need not go there. I assume that the court's satisfied. This could be an interesting argument as well. Whether or not the court's satisfied mitigating factors do exist that would support a departure downwards. The state didn't bother to address that. They're just convinced under the circumstances 1095 is controlling, and that their interpretation of the statutory scheme and or the charging language in this case and or 9A and 9 is absolutely correct. And that, gee whiz, they want to talk to Mr. Boysen about the fact that maybe I suggested maybe they're not correct. Well, there's a host of other cases that have gone up previously, dating back to the 1980s, that addressed in some respects similar arguments. But they weren't the same argument, and that's why they're not controlling. This case is unique under its facts and circumstances asked the court to basically grant the defense request. You know, it's interesting, too, for purposes of all the parties that are involved in the courtroom, we're asking for an exceptional sentence downward 40 years. 40 years. But that's not enough. Mr. Boysen will be eligible for release at the age of 67, if in fact the court grants that request. Obviously, the state doesn't think the court has the power to grant that request. 40 years is fairly reasonable. I refer to a Kansas statute. Basically, it describes what they describe as a hard 40. And that's the most serious penalty you can get in the state of Kansas short of death. It's a reasonable request. We think that Mr. Boysen has the legal ability to make that request of this court, aside from what it is the prosecutor thinks, a proper interpretation of the statute should be, and we request the court consider our request, if you will, for an exceptional sentence. Thank you, Judge.
Okay. Thank you. There's one thing about Mr. Conroy's presentation that the state does agree with, and that is that we did not address in our response memo the factual basis for his exceptional sentence down, the mitigating circumstances that I think Mr. Conroy believes exist in this case, because it's not appropriate, first of all, legally, or I guess most importantly, legally. There's no authority, whether statutory or by case law, that distinguishes the sentence in this case, whether someone goes to trial or enters a plea of guilty, whether it be a straight plea or an Alfred plea. The language used by the statute is conviction, not trial, not plea. It's a conviction. So, as the court knows, a conviction can occur in two main ways: trial or by a voluntary plea of guilty, which is what happened in this case. Now, Mr. Conroy also makes a big deal of the fact that the defendant, the information, is charged by way of Title 9A and also in Title 10. Well, again, if you look at the actual statutes, it makes sense, and that's why it's charged that way. RCW 1095-020 says that a person is guilty of aggravated first-degree murder, a Class A felony, if he or she commits first-degree murder as defined by RCW 9A 32030, subsection 1, subsection A. And now or hereafter amended. And one or more of the following aggravating circumstances exist, and that lists several aggravating circumstances. So that's why the defendant has to be charged under, or at least the information informs him of those two different statutes. That it's first-degree murder, and then on top of that, the aggravating circumstances which make it aggravated first-degree murder. The following section in Title 10 is 1095-030, which is entitled Sentences for Aggravated First-Degree Murder. And it states, except as in provided in subsection 2, which is the special sentencing proceeding for the death penalty, any person convicted of the crime of aggravated murder first degree shall be sentenced to life imprisonment without the possibility of release or parole. A person sentenced to life imprisonment under this section shall not have that sentence suspended, deferred, commuted by any judicial officer, and the Indeterminate Sentence Review Board or its successor may not parole such prisoner or reduce the period of confinement in any manner whatsoever. The statute is clear. It's unambiguous. It doesn't refer to pleas. It doesn't refer to trials specifically. It refers to a conviction, which is what we have in this case. As if the statute is not clear enough, the appellate courts have repeatedly, and I'm not going to cite the cases for the court, they've been provided in briefing, but the courts have repeatedly held, number one, that the statute actually means what it says, that there is no possible sentence. For aggravated murder in the first degree, there are only two possible sentences: life without the possibility of parole, or the death penalty. And in this case, Mr. Conroy is right. The state chose not to file the special sentencing notice, so the death penalty is not available. The state's not seeking the death penalty in this case, which leaves the only possible sentence, which is life without the possibility of release or parole. Not only have the appellate courts, including our state Supreme Court, held that repeatedly, but that is the only available sentence, and that an exceptional sentence is not available. The courts have also held repeatedly that the statute is constitutional, that it does not violate due process, that it does not violate equal protection. So the arguments made by Mr. Boysen's attorneys are not supported by statute, by case law, or any other authority that the state is using. So because of that, the state asks this court to rule and find as a matter of law that an exceptional sentence is not available in this case, and that the sole sentence in this case is life imprisonment without the possibility of release.
Anything further, Mr. Conroy?
The state, in its interpretation, if you will, the statutory scheme and the charging language in this case, has chosen to ignore the facts of the case that it wants to rely upon in order to support its position here today. When the court goes back to the statement of defendant on plea of guilty, nowhere in this statement do they talk about which statute it is that Mr. Boysen is convicted under. Nowhere in it he says he pleads guilty to aggravated murder in the first degree. It doesn't say under 9A 32030, subsection 1A. It doesn't say 1095-020. It doesn't say anything like that. It just says aggravated murder. There are standard sentencing ranges for aggravated murder.
Well, isn't it pretty common, Mr. Conroy, to basically read into the defendant's statement on plea of guilty the information that he's being charged under, so that, that's obviously notice to him of what he's being charged under. I don't think that it's necessary to repeat all the statutes in the actual guilty plea form.
I'm not in charge of the colloquy in this case. The state was in charge of the colloquy. The court heard the colloquy, and the court made a ruling based upon the colloquy. The plea was being made knowingly, intelligently, and voluntarily. But the state has all the other authority in this case to charge what it is they choose to under the circumstances, to seek the death penalty if they want to. At what point do we decide that there should be some limitations on that power? I think the time is now that this court should decide that there should be limitations on discretionary charging calls, much less more whether or not the state can seek certain sentencing options. Now, that's already been done in McMillan v. Anderson. Monfort has yet to come back from the Supreme Court, but the issues were slightly different than Monfort, but they weren't McMillan and Anderson. But the time is now to decide whether or not the state can eliminate sentencing options by virtue of an unfettered discretionary decision, charging decision. That's not right. That violates due process. It violates equal protection principles. It violates the 4th, 5th, 6th, and also the 8th Amendment of the United States Constitution. It's being cruel and unusual. I would also add that to the record today. We've got to step in at some point. As the Supreme Court noted in dicta in Ortiz, that there has to be a point in time wherein somebody recognizes that the quest for, it was great language actually, justice to fit each individual should not and need not be sacrificed in the quest for uniform sentences. But there again, this case is distinguishable from all the cases the state wants to rely upon. Those all went to trial on a charge of aggravated murder. There's no indication anywhere in any of these cases, if you will, what statutes were prevailing, what statutes were charged, were charged with conjunctive or disjunctive. Nothing. There's no indication of that effect whatsoever. They don't address the unique circumstances of Mr. Boysen's case, and that's why we consider it to be distinguishable. And we're respectfully renew our request to consider the imposition of exceptional sentencing. Thank you, Judge.
Well, I agree with the state. I don't think that there is any alternative under the statutory scheme for any sentence other than life without parole. The statutory scheme is very clear. The statutes all fit together. There isn't any inconsistency between the different statutes. The statutory scheme, as Mr. Yip pointed out, provides for a definition of what is ordinarily first-degree murder, and then also provides for aggravating circumstances that can make it aggravated first-degree murder. There's nothing inconsistent about those statutes. And there's no constitutional problem with any of those statutes. They've been challenged in the past. The case law doesn't indicate there's any problem with them, and I think that it's clear that the only sentence available here is life without parole. So I think we're probably ready to proceed to sentencing then. Sure.
Again, I'm not going to ask the court to ask the defendant if he agrees with that. But I do believe that it is important for the court to ask the defendant, knowing what the court's ruling is, does he wish to stand by his plea and continue his sentence?
All right. So.
Your Honor, I think there again we're going to interpose an objection. Now the state's asking this court to ask Mr. Boysen to agree with the court's interpretation of controlling statutes in this case. We have advised him to remain silent. There's not going to be any additional colloquy in this case. Colloquy is complete. It was more than adequate previously. The state made its arguments. We made our arguments. The court has ruled. It's time to proceed to sentencing. Mr. Boysen will not be answering any other questions with respect to which statute is controlling. Will not be the reason for the court's interpretation or Mr. Gibbs' interpretation of the statute in question.
Okay. Well, I don't think that obviously that what the state is asking is that Mr. Boysen agree with the state's interpretation. Nevertheless, I think the record is abundantly clear that Mr. Boysen was informed at the time of the plea that the only possible sentence was life without parole. That's in the plea paperwork. It was covered orally during the plea. I don't think there's any question that that's what was involved, and so I don't think it's necessary to conduct a further colloquy at this time.
Your Honor, this is a case of obviously although this is a case obviously of great magnitude, the state will keep it very short. I think the most important people in the court to hear from are members of the Taylor family and from the defendant should he decide to speak to you. Your Honor, the facts of this case, which I won't go through, but the facts leading up to the death of Robert and Norma Taylor, the facts that surround their killings, and the facts after their murders support the most serious charge, the most serious criminal charge that we have in the state, which is aggravated murder in the first degree. That's 2 counts. The defendant has pled guilty to both of those. And the only sentence available is life imprisonment without a possibility of release. And in light of the facts, in light of the seriousness of not only the facts, but of the appropriate charges of this case, the state believes that the sentence is not only legally binding upon the court, but it's the right sentence. So based on that, the state is requesting this court sentence the defendant to life imprisonment without the possibility of release or parole in count 1. Also in count 2, the laws that they must run consecutive to one another. The state is also asking the court to impose the mandatory $500 victim penalty assessment, a $100 DNA fee. The family members have indicated that they are okay with contact with the family. There's only one caveat to that, or 2 caveats, and that is that Robert Taylor and Suzanne Taylor are asking that the court order the defendant not to have any telephone contact with them. Or, I'm sorry, Suzanne Kim and Robert Taylor. And we'd ask the court to respect those wishes and enter that into judgment and sentence. The state's also asking the court's ability to note a restitution hearing should one be necessary within the statutory framework. And when it's Mr. Conroy's turn to speak, I would ask that he indicate whether or not his client waives his presence, if such a case is necessary. Besides that, Your Honor, I want to just turn it over to the Taylors. So my understanding is that Melanie Taylor, daughter of Robert and Norma Taylor, and the defendant's mother, would like to address them. Accompanying her is her brother, actually written a letter to the court that he's asked Karen Cundy, victim advocate, to read on his behalf.
Okay. So if you want to go ahead and
Sorry,
take.
I think you need my glasses after all. Your Honor, and people in the courtroom, thank you for giving me time to share some thoughts today. My name is Melanie Taylor. I'm daughter of Norma and Robert Taylor. I'm mother of Michael Chad Lewis Boysen. Today is the day that my son, Michael Chad Boysen, receives his judgment, his sentencing for a horrific crime that most of us cannot even fathom. Over the past 7 months, I have heard and read so many things about my son, my parents, and myself. People trying to make sense of this horrible tragedy that happened March 9th. People making judgment. I have heard and read comments about Chad that makes my skin crawl. I have heard and read comments about my parents, Robert and Norma Taylor, that makes my heart bleed. The judgments from others that have been so quick to point fingers, get a story, and say things about people they know nothing about. I would like to take a moment of your time to give Your Honor and the people of the courtroom a sliver of that day about my parents and about my son. March 8, 2013. We had had a lovely family dinner at my parents' welcoming my son home from prison. The traditional roast, potato, and gravy dinner had been prepared, and the beverage of choice was not alcohol as indicated by some of the papers. It was chocolate milk. The family gathered together that evening to give Chad our love and support as he had made the decision to go into a program that would help him with his addictions and his transition back into society. The road had been a tough one for everyone, but we are family. We are there to give love and support to one another. The talk of the evening had been mostly my parents, sharing the wonderful day they had had with Chad, picking him up from prison, working on his checklist by taking him to various places he needed to go before he could begin the recovery program. I remember my dad saying how he had enjoyed his time with Chad and how much he had missed him. You see, Chad's grandparents were like second parents to Chad, my son. The evening quickly drew to an end, and as I got into my car, I drove away from my parents' home, like I had done 1,000 times before. I looked back in my rearview mirror. There on the front porch was my mom, my dad, and my son waving goodbye. My mom signing, "I love you." It brought tears to my eyes to see the three of them standing on the porch and to have my son back with my family. The next day, March 9th, I received a phone call from my daughter. She stated that her aunt had gone over to pick up Chad at my parents' house, but there was no answer at the door. My daughter was worried that something was not right. I told her, no worries. I would call and text and find out what was going on. No answer. I then decided to go over and see what my parents were up to. My first thought was that my mom had taken Chad shopping. Grandma loved to shop. And she stopped and spent more time shopping than had planned. I headed over to the house. As I rang the doorbell, I got no response. Being that my mom is deaf, I let myself in with the key. Once inside the house, I began to call out for my dad and Princess the dog. With no response, I began to look around. The car was gone and no one was to be found except Princess the dog. She was in the parents' bedroom with the door shut. I sat down and waited for them to return from shopping, and as I sat, I began to realize things were not right in their home. I looked deeper this time. Opening the guest room closet door, I could not believe what I saw. I opened and shut that door 3 times in hopes that what I was seeing was not for real. My parents were piled on the closet floor in a manner I will never forget. I reached over to take my mom's pulse to discover my mom's body had been lifeless for a very long time. Running to the kitchen to grab the phone, I called 911. My heart was pounding and my entire body was shaking at the sight I had just seen. This could not be real. This isn't for real. what had happened and why. What seemed like forever and a day, the police arrived at my parents' home. The very terrible nightmare had just begun. My daughter, sister from Everett, and boyfriend were at the house in a moment's notice. My brother from Idaho and my sister from Utah were there the next day. The family gathered and cried, hugged, and tried to make sense of the entire tragedy and what was facing us as my son was missing. The weight that was weighing on all of us was more than I can ever put into words. The loss of my parents in a manner which their lives were taken were more than horrific. Since that day, I've spent much time reflecting. I discovered, as I always know, my parents' true character shines in my siblings and my daughter. What may have torn most families apart has brought us close together. Robert and Norma Taylor are true examples of unconditional love. Their kindness, giving hearts, and true love truly shines in my brother, my sister, and my daughter. I miss my parents more than you will know, but I take pride in seeing their character, their values, and love shine in my family. I can honestly say my parents were warrior spirits for my son. They were the brave warriors fighting for the cause. The cause was their grandson and the drug monster and mental illness within him. Whatever transpired that horrible night, I know my parents would have done anything to help their grandson, even if it meant giving up their lives to do so. They love Chad, as they do each family member, more than life itself. I love you, Mom and Dad, and I miss you so much. My son, Chad. On May 24th, 1986, I received a phone call from the adoption agency that our son was born and that he'd be ready to pick up the next day. I cannot express the excitement that day and what a challenge it was to sleep that night. The next morning, Dad, sister, and myself headed to the adoption agency to pick up our new family member. They put us in a room with my son for about an hour to get acquainted. The hour passed quickly, and staff members returned asking if we wanted to keep our son. I still remember 3-year-old Brittany telling the staff as she held on to her little brother's hand, "He's my brother. You cannot take him from me because I love him and we are keeping him." Michael Chad L. Boysen became a member of our family that day. Chad was a true blessing in our lives. His grandma Noni, which is Norma Taylor, named him the Smiler because he was always smiling. His smile was contagious. When Chad was 3 years old, his father's truck was hit by a drunk driver. His father was blessed to survive the crash. He became a very fragile man from the impact of the crash on his body. As a young child, Chad felt he needed to take care of his mother and his sister. His father's health was unstable for many years. Chad took on the job of being responsible for his mother and sister. Chad continued to grow, enjoying things most boys do, learning to play with friends and attending preschool, elementary school, high school, and even running Star. Chad enjoyed many activities: baseball, Cub Scout, soccer, lacrosse, track and field. He even enjoyed performing at piano recitals. He played at one recital with one hand because he had broken his wrist the prior week. It was a joy to my heart to watch both Chad and his sister run cross country together. Chad grew up enjoying books, volunteering in the community, being a rescuer when children were being bullied. He was truly a smiler and people enjoyed his charismatic personality. Things began to change in Chad during his teen years. Simple things would irritate him. He began to lie about things and became angry over the small stuff. Chad had made a terrible choice to take drugs. Chad became addicted to drugs. Our life as a family and Chad's life would never be the same. The next several years were more painful than I could express in words. Many efforts were made to help my son. I sat through many groups and counseling. He went into several rehab centers, counseling, served time in prison. It was a very hard time for myself and my family. Never once did our love for Chad ever stop. We hated the choices Chad had made and was making, but we have always loved you, Chad. Many years have passed with many challenging mountains that have been climbed, and here we are in the courtroom facing my son's sentence of life in prison due to a guilty plea for a double murder of my parents, Chad's grandparents. A parent's worst nightmare. Where did it all go wrong? Chad had all the love and support a child could ask for or want. How does life go wrong when so many things are right? Chad always had love from an entire family, not just from his immediate family. He never went to bed hungry. He always knew his home was a safe haven and had many opportunities most children don't have. How does a person with great potential, wonderful personality, smarts, and good looks be headed for life in prison? How does a person take the life of his grandparents that loved him more than life itself? Everyone looks at the tragedy and asks why. Drug addiction is a horrible thing. Drugs can turn a wonderful person into a monster. Drug addictions hurt not only the addict, but the family and friends that surround the person. And so here we sit in the courtroom awaiting Michael Chad Boysen's life in prison sentence. What can I say to make this better? To rest at night, to know justice has been served from both the lives of my parents and my son's life. This is a no-win situation. I would ask the courts to ensure that Chad is in a facility, that he can get help for his addictions and his mental illness, that somehow, some way, he can become a better person in the environment he's placed in. I love you, Chad, and always will. I will never understand what happened on March 9th, but I want you to know I will not and do not judge you, and above all, I do forgive you. I love you forever. I love you for always. My son, you will be. In conclusion, I would like to thank those that have worked so hard, both the prosecution and the defense, and all the detectives, the family advocate, the King County PIO, King County prosecutor staff for being so good to me and my family during this more than awful time in our lives. Your professionalism and kindness has helped us more than you will know. Thank you, Honor, for giving me time to be able to express myself today.
Sure. Thank you.
Thank you, Your Honor. My name is Karen Cundy. I'm a victim advocate with the King County Prosecutor's Office, and Rob Taylor asked me to read a letter on his behalf.
Okay.
Your Honor, I would like Chad to know the following. They say blood is thicker than water, but in Chad's mind, blood is cheap. It is hard to imagine that one human could do such a cold, violent act as has been done here. But to do it to family, two elderly family members that have reached out and done so much for him is shocking. I remember so many times Chad's grandparents telling me how proud they were of him, trying so hard to turn his life around, like when he was doing therapy for his paralysis, or working so hard when he was cleaning ducks for restaurants, even though it was a dirty job, and many more. Chad was working so hard. I think of all the deception over so many years. Chad was clever. He knew just how to play people to get what he wanted from them. He could defiantly turn on the charm. I wonder, as he planned it out for months ahead of this time, how he felt. And at the family gathering, he put on a great act. He acted so happy and grateful to be with his family, all the while knowing what he had planned for that night. Then I think of later that evening when he so cowardly came from behind and wrapped a cord around my father's neck and choked him as he struggled, the most that an old man could. As the life left his body, I believe at that point he saw his grandson still choking his lifeless body. And then all the deception was gone. He saw Chad as he really was. And then to watch his body dragged and thrown into a closet. And then Chad would bend down and pull the wedding ring off his finger. To Chad, that was just easy money. I wonder of the horror as my dad watched Chad then go to his wife and again attack her so violently as to break her neck. An 80-year-old woman that had a hard time even walking. The same grandmother that would drive miles to pick Chad and his sister from the bus stop so they wouldn't have to walk a few blocks home. Then I believe my parents watched as he dragged her body and tossed it into the same closet of the very room that they had Chad stay in so many times. I can't imagine the pains they felt as they watched him so carefully loot their home where so many family memories were made, the home that he was always welcomed at, even after he had violated it. They had put so much trust in him that he knew just what to steal. The silver dollars my mom's grandfather gave her on her birthdays when she was a child, the jewelry she had collected over her lifetime, including her mother's and her own wedding rings, the silverware that she collected while she and Dad courted. Things that had very sweet sentimental value were just things to be pawned for some quick cash to throw around. Chad said it made him mad that his family wanted him sober. It's sad that he embraced the very thing that caused so much pain to his father and family. I'm sure the driver that hit his dad said the same. Just let me do what I want. I can handle it. It won't hurt anyone. Well, it has. Chad said it made him mad that his grandparents expected so much of him. And yet that's what grandparents do. They see the potential and want you to succeed in life. And they have the wisdom to see beyond the here and now. I remember my own grandfather telling me over and over how important an education is. Sometimes it was irritating, but now I see his wisdom. Chad is intelligent, has a dynamic personality and a healthy body. He could have done so much, but chose over and over again to trash it, to take advantage of those who tried to help him. Chad will meet many inmates and will realize that many would not be there if they would have had someone who believed in them, someone to support them, someone who even cared about them. They will not believe the love and support that he had from his family that saw so much potential in him, and he turned on them. Chad will see himself in the mirror and see his true self. You cannot deceive yourself, although you might try, but underneath you know. He will wonder if this life is all there is to one's existence, or if is there something after death. I wouldn't want him to be anxious to cross that line, as he may want to ponder that for a while. Chad needs to take ownership that he has made the decisions that have brought him here today. No more excuses. They were his choices. It's not a game to see what you can get away with or how much you can con someone. There are real consequences that affect many people. He not only took the lives of two good people, but he also took them out of the lives of his family, their friends, and community. He has also severed his own family. He will never be able to share the mountains with his kids, watch them play sports and activities, and help them with their homework, watch them grow. He has deprived his parents of being grandparents. After this generation, he will only be a file with thousands of others in a dusty storeroom. He was mad because his family wanted more for him than to live in a drugged-out stupor. And yet there is something I don't think he will ever comprehend. I'm sure they still love him. He is still their grandson. He is still blood. Thank you, Your Honor. Rob Taylor.
Okay, thank you.
Yeah, this is Sue Kim.
Okay.
Your Honor, my name is Suzanne Taylor Campbell. I'm the second daughter of Norman and Robert Taylor, of 4 children. I'm here today with very mixed emotions flowing through me, and I hope I can convey how wonderful my parents, Bob and Norma, were and are, as I believe in an afterlife that they are there. My parents taught me to be honest, to be charitable, and many other great qualities by word and by their example of their daily living. My parents took in people who were needing a place to live, from an 18-year-old girl that was kicked out of her home to a young couple that was struggling when they lost their job and were down on their luck. They treated them just like family. They helped them and others with their emotional and monetary and other problems that they had. They helped others repair and fix homes when they had problems. My father and mother made many crafts projects together and donated them to charities for auction for good fundraisers. My dad would cut out wood projects for the Cub Scout day camps and for the church women crafts for free. My mom crocheted hundreds of baby hats for hospitals for the I didn't write it down. For the preemie infants, and also for the fire department. My mom made hundreds of embellished Christmas stockings every year for the servicemen. She loved her country, and almost every one of her coats always had a flag on it. She loved America. She also was deaf and could not hear for the last 30 years. The only grandchild's voice she heard was 3 of them. The rest were born after. But she loved her children, grandchildren, and children. They served in their church in teaching the young men and young women and had leadership roles. My dad was what they called a patriarch for the Church of Jesus Christ of Latter-day Saints for many years and gave over 1,000 patriarchal blessings. They are loved and respected by about a congregation area of 5,000 members. A week after their death, a retired Safeway employee came by their house while we were there and paid her condolences. She had worked for Safeway for 30 years and looked forward to seeing my parents come in every week. My parents reached out to the community for years, and Chad has taken that away. Because of Chad's actions, me and my family will no longer be gathering in their home for every other week pot roast and mashed potatoes for Sunday dinners. We no longer will be with them for holidays and birthday celebrations. They won't be coming to my house for Christmas Eve for scones, but it's been a tradition since I've been married. We won't be having our annual Christmas crafts in their house that we had family and friends come to. Most importantly, I will not have their kisses and their hugs anymore from them. My mom, since she was deaf the last 30 years, her communication was not by phone, as I lived an hour away, but it was by email, and then this last year she started texting. I will no longer receive her texts and email. My sister would write her every single day, and she has not that anymore. Her emails were encouraging when we were down and also congratulating us when things were good, when the grandkids did good things. It was very painful and shocking to have received the call from my sister Saturday evening, March 9th, telling me she had found our parents in the guest bedroom closet that Chad had or was supposed to have slept in. My sister has that image stuck in her head of my parents' discolored bodies with my mom stacked on top of my dad. Just 24 hours earlier, we had been in my parents' home having dinner with no alcohol, as they do not drink, and many of our family do not drink. Chad had gotten back from serving a prison term. All seemed fine when I left. In fact, around 10 o'clock, I had texted her and said I had left something there, could she find it? And she said she had. and she also always wanted to know that we got home safe. Chad was missing, the car was missing, and as time went, it was discovered that money and jewelry and sterling silverware were missing. We all felt Chad was the one who had killed them. Most of us were scared he would come after us. I could not sleep well for several nights, thinking he may come to my home in Snohomish County, especially since prior to that previous sentence, he had been caught twice up in Snohomish County where he was not supposed to be and high on drugs and had his car impounded. I had to help my sister, and my dad helped her pick up the car and get the car at 2 separate times and take them back. So I thought that he would come back up that way to get his drugs. So it was a huge relief when he was captured down in Oregon. Another thing that was hard since that time is when their bodies were taken from the coroner's office to the funeral home. My brother, my other sister Debbie, and I went and identified them. My mother's face was barely looked like her, and my father's face was very, very discolored. The other thing that was hard was I was the one to call my mom's sister that she was very close that they could finish each other's sentences and tell her that her sister had been killed. They were totally shocked and disbelief. I called my dad's brother and had to tell him the same thing. He had to call me back later because he just could not believe it. For insurance purposes, for some of the jewelry to try to get some money back, we had to make a claim. We had to see the things, and I had to work several months to try to get it arranged, and we were finally able to see the pictures of some of the jewelry that was stolen. And to see my father's wedding ring was especially hard because for 59 years he never took that ring off. And they had just celebrated a few days before their death, their 59th anniversary. I have 4 children. My son, the oldest, Stephen, and his wife flew in from Georgia. He and I talk a lot more on the phone, discussing Chad's case and helping each other deal with this tragic impact in our lives. My son Josh was living at home at the time until Chad was caught. He did not feel safe staying at home, so he stayed at a friend's house for several nights. Then a month or so later, he moved out of state to live with my son Ricky. One thing that I said that I found out this week is that he felt Chad on that night of when he got out on the 8th. Chad had showed him a hatchet. And so he had been around when we knew it was a strangulation, and he didn't want to read or talk about things. And so he thought Chad had chopped them up until July 20th when he talked to one of the police officers and when he found out different. So I can't imagine having that in my son's head for that long. It was emotional, confusing time. My daughter Tiffany left on a mission a year ago, October 10th, in Brazil. And so I've only talked to her once for 20 minutes, and all communication has been done by email. She couldn't come to the burial, but she says she prays for us and Chad daily. Another hard thing is the police confiscated my dad and mom's computer. He was working on his life history. We have a few copies of some of his pages, but his life history is in that computer. We do not have access to that. We may never get their wedding ring back. We may never get any of those things back. We will not get my parents' life back. And this is because of Chad. It hurts deeply that Chad has done an outward plea. He says that he did not premeditate. He is the one who got mad at my parents. He is the one who changed the plan when he got out of prison. He was to sleep at my parents on Sunday night, but he switched it to Friday night. He is the one that killed, and if he thinks that wasn't happened before, He had to kill one before the other, so he had to plan and take a shoelace off his shoe to do it. That was planned. He says he does not remember that night. Well, he had enough ability to remember that we all knew Grandma saved and hid money somewhere. He found that money, but none of us knew my father had saved money too and had it hidden. He did not go through all of his grandpa's drawers, and we found money there.
Bullshit.
Mr. Boysen, be
Since
quiet.
Chad has lived at my parents several times in his childhood and in his adulthood, he knew where the real jewelry was and where the expensive was and what was costume jewelry. Most of all the costume jewelry was left behind, but all the real jewelry was taken. The house was not a mess because he knew where it was, and if he made a mess, he cleaned up after himself. He also turned off a radio and a TV in his room in the house before he left, because when someone turned on the TV when we were there, it blasted loud, hard acid rock. And so we went in the bedroom and turned on the radio that was in the bedroom he was supposed to sleep in, and the same thing, loud acid rock, was blasting. My dad listens to Doris Day classical music. My mom is deaf. No one else would have listened to that music but him. He says he is clean to help our family out, but in my heart I would like him to prove me wrong, because I think he's doing this for himself.
Fuck you, this is bullshit.
Mr. Boysen, sit
will
down. You
not
will
find the
have
right
your
thing.
turn.
He will, listen, he will appeal this because he'd rather be in prison than in jail. In prison, he will be in a better place than jail. He can have his TV and his radio, which his lawyers have tried to get for him before now. He'll have his library, his weight and track. In the past, he's claimed that he was studying Judaism so he could get kosher meals when he was in prison before, so he wouldn't have the regular prison food. He constantly lies. He's stolen from his girlfriend's home. He's stolen from my parents' home before this. He had faked his paralysis that my parents had taken for several doctors 4 to 6 times a week, or 4 times a week for physical therapy sessions for months to support his drug addiction. During his first felony case, he wrote and apologized and told them that he had faked the paralysis. Your Honor, I love Chad. You are my family.
Sure.
But the society and my family's sake, he needs to be in prison for life, where he can no longer take advantage or take someone's life because he got mad at them or that to support his drug habit. He will do anything to get what he wants, and he has not shown any remorse. I have not heard him ever say sorry. Thank you.
Thank you, ma'am. So are there any other family members? Okay. So, Mr. Conroy?
Thank you, Ryan. I think at this point, Chad's hands like to address the subject.
Okay, sure. Do you want to come up here, ma'am?
Your Honor, my name is Heidi Boysen Sentencing, and I would like to address the prosecution, the defense team, and my nephew Chad. To the prosecution, thank you for not seeking the death penalty. My nephew means the world to me. To the defense team, Jim, Scott, and Chad back there, thank you for your tireless work to keep Chad alive when he was in jail. Thank you. Thank you for your hours on the phone with me to help me sort out my feelings. Thank you to your dedication in Chad's defense. And to Chad, I love you. Believe me, I will never forget you. Ever. As I have visited you for years now, as I have supported you, as I planned for many things for you and will continue to plan for many good things for you. As you build a community, you will find your purpose. I will help you do that. It's a promise I made to you, and it's a promise I will keep to you. I was given a gift from my God to be able to love unconditionally. And that is one thing that I have from Dad, is deep unconditional love. And the last thing I want to say is a promise that I've made to your dad, Chad, my brother. I will be his eyes and his ears and his touch when he can't be there like he wants to be. His health made it so that he can't be here today. But I have promised him that I will be there for him, for you, forever. I love you, Chad.
Thank you, ma'am. So, Mr. Conroy?
Thank you, Your Honor. Your Honor, first, I also want to thank the family. I know it's a very difficult time for them. I think it's sad because at one point I had hoped that we might pursue trial not to dispute what it is that has happened, but to try to get some answers about why it is it happened. There were a couple of brief statements made in records from the Department of Corrections before Mr. Boysen's release. I think that almost perfectly captured what was happening. Michael Boysen, they say, himself is a seriously mental offender being released from MCC SOU, where he received mental health treatment. He has manic episodes, but he has a history of suicide attempts and ongoing suicidal ideation. It is stated that he plans to kill himself when he's released to the community and will be assessed for a 7105 civil commitment prior to release. Unfortunately, and there's several indications in the records from the Department of Corrections that at the time of release, he, Mr. Boysen, should be referred for 7105 due to harm to self. As I think everyone in this courtroom knows, Chad has attempted to kill himself on many occasions since his incarceration in this facility. He attempted to kill himself before he arrived at this facility. And I'm hoping that he will stay with us so that he can help his family, perhaps heal some wounds, if that's possible, perhaps to try to answer some questions which we had hoped to answer in the course of the trial. But time will tell. I think Chad would now like to briefly address the court with respect to
Good morning, Your Honor. Thank you for giving me the opportunity to talk today. Before I was to speak directly to my family and those affected by my crimes, there are a few things I'd like to say beforehand to some other parties. I'm by now thoroughly disgusted with the officers and the prosecutors who invested this case, as well as the fast and loose way that the media has reported on it. For example, reporting that there was alcohol at a family dinner, Mormon family dinner. Reporting that the premeditation, the guns, the bombs, wanting to kill authority figures, all of that crap. I suppose that I was naive coming into this thinking that the system is more often fair than not, that it would operate at high ethical and moral standards, particularly when a man's life is potentially at stake. Don't worry, I am naive no longer, and I have no illusions about those high and moral ethical standards anymore. the true colors of the lead detectives shone through very early when they came to question me in Oregon while I was in the hospital. I had barely come out of anesthesia, literally had only been awake for a minute or two. I had no idea where I was. I had barely had any idea what my name was. Lo and behold, Detective Bartlett walks in and starts to question me. I initially told her that I was confused and to come back later. I was really confused. Did that stop her? Of course not. She continued to ask her questions until I finally just asked for a lawyer. Of course, I had to ask more than once before she finally left. Questioning a barely conscious suspect, it might be legal, but I find it sleazy. Throughout the entire investigation, the detectives have routinely held back evidence for absurdly extended periods of time, as well as potential death penalty mitigation. Nearly every time I was in court, I would press my lawyers to ask the judge about any discovery and my concerned lack thereof. Almost every time, we were assured by the judge that things would be turned over in a timely manner. Really, timely manner. When I pled guilty 2 weeks ago, that morning I was handed over discovery that was produced almost 7 months ago. I don't think that qualifies as a timely matter, at least to me. Not to mention the 40-minute videotape recorded statement tape-recorded statement from one of the inmates that I allegedly confessed to, one of your reliable sources, we still have not received, which goes all the way back to March as well. I think both these examples is an unfortunate proof of how the state attempts to hold all the cards, retains evidence longer than necessary in an attempt to gain the upper hand. It's apparently a routine practice. Again, I had the naive thinking that the system was supposed to be fair and equitable. Potentially more damaging was the anti-mitigation work that the state was engaging in, holding on to family statements longer than necessary, as well as intimidating my biological mom, whom my legal team found as part of their mitigation work. That was the one that really pissed me off. When my lawyer first made contact with her as part of my mitigation work, trying to find out about medical history, possibly, and mental health history in my family, he explained he was my attorney, and he explained his reason for calling. Afterwards, when the family called the detectives to confirm his story, saying that they were concerned, the detective told them to be careful, lock all your doors, and don't talk to strangers. Needless to say that my lawyers never got a meeting with her. We've never heard back. How would that make you feel? I've never really grown up with a desire to know my biological parents because my own mother and father, who I consider my mother and father, are the best parents anybody could ever ask for. But in this case, it broke my heart knowing that possibly any further communication in my life would be trumped because the detective wanted to keep her away from us and from anything that would help us. It's absolutely disgusting. It's even more ridiculous because, of course, the lawyers know who my attorney is. So when they call her... Another thing that really gets me fired up is the prosecutor trying to force me to give away my confidential health records as well as personal interviews with my mental health staff. These are super personal pieces of me that I didn't want to give away. Personal family stories and life experiences that mean a lot to me but have nothing to do with this case. Maybe they falsely hoped that there was a confession hidden inside somewhere. So because I didn't want to give them up, the prosecutor attempted to rip them away from me. Another thing that gets me fired up, really fired up after hearing my aunt and my uncle talk, is the police saying that they supposedly have 2 super reliable witnesses in prison that I confessed to all this premeditation, that I'd been planning this for months. I would like you to know that their reliable witness and their evidence is based on 2 inmates at a mental health prison that I was at. The first Henry, and I've read both their statements, by the way. The first, Henry Maynard, is on Social Security because he is schizophrenic and an admitted crack user and alcoholic. He even says in his transcripted police interview, mind you, the one that they rely on all this crap, he says this word for word, and I quote, "I can only say that my recollection was driven by what I saw on the news this morning," unquote. Gee, that's sure came up with their information on their own or from me, and he admitted it, that he saw it on the news. It is also interesting that he was recently released not too long ago and rearrested on theft 3 and indecent exposure. Nice, reliable witness. The second supposed reliable witness is George Tolo, who during his interview with my attorneys indicated that he has multiple mental health diagnoses, takes medication, and has been put into Western State Mental Hospital. He also told my attorneys that if he gets out of prison, he's going to, quote, "do something like Boysen did." Great. 2 superstar witnesses that you assholes found to use against me. That makes my family believe that I premeditated this for months and months. Great. Good evidence. Nice, guys. And this is where the media gets all this information from. Where you guys get this gun, bomb, premeditation, killing authority figures crap. I want to kill cops and blacks and Jews and all this stuff. This is where you get that from. Thank you. It is interesting to note, however, that King County Sheriff Urquhart gave a radio interview after I was arrested. In his interview, he mentioned that I had no history of violence, and it seemed out of character for me. It's a long cry away from blowing up in an interview and giving news conference on how dangerous I am. And this was just a short week after. Great. I guess you guys felt free to slander my name and put my family in the news at the cost of people's lives. I also briefly want to talk about my time here at the King County Jail, which my aunt said is the only reason I pled guilty is to escape from here. It's not true. My 7 months here at King County Jail can only be described as traumatic. It shouldn't be, given how most of the correctional staff here either spends time talking on their cell phones, text messaging, browsing the internet on their cell phones, or watching TV shows and movies on their tablets. The fact that cell phones and tablets are even usable at work seems absurd to me. The fact that these items are even allowed in this facility is mind-boggling. The only thing more stunning than the time wasted on the job here is the simple ineptitude of the officer that works here. Maybe that is why in the not-too-distant past, which you can find out anywhere you look online, the Department of Justice was forced to do a comprehensive investigation on this facility into too many inmates successfully committing suicide. As far as I can tell, the officers who work the court detail here are the only ones who take pride in their work and act with professionalism on a daily basis. I understand that I have not been the easiest inmate to deal with. Since I've been here, I've had 14 instances of self-harm, some ranging from minor all the way up to finding me unconscious and unresponsive. I've had 4 blood transfusions in the time I've been here. I've gone to heart review 16 times. 4 times I've been under the knife for surgery to repair damage or to survive. I feel like that might be a hint that something's wrong. The only way that they felt they could deal with me is to strap me down to a board or to a bed, which seems absolutely ridiculous. My lawyers brought that issue here to court, and even the judge said, "Hey, it seems like a logical thing to do. You're being willful." I'm not being willful and have not been willful. I have had the urge to die, a compulsion to harm myself that I can't stop. I can't get out of my head. There are other ways to deal with this than strapping somebody down to a board or to a bed. I've now gone over 50 days without harming myself, and that's the longest I've gone here at the King County Jail. It has nothing to do with them having strapped me down. It has something to do with them trying something different, giving me decent mental health care, giving me someone to talk to, maybe trying different medication. They would have you think that I'm just a drug addict, showing drug-seeking behavior, trying to get to the hospital. If they look at the records, they don't give me drugs when I go to the hospital. I also have to put up with crude comments from officers regarding my case, my mental health problems, constantly. Even officers who aren't even on my unit, not even working there, will come by just to say something in my window. During a misunderstanding with the officers, I was tased and restrained, which is my fault, I guess. I stood up a little too quickly, two sudden movements. But then I was punched in the back of the head by Officer Drake. That upset me. That really upset me. So when we come to court, we find out that the videotape is missing. In the last 3 years, the only time there's ever been a problem with that video system is right then. In 3 years, the only time it wasn't recording was right then. Seems very convenient. A few days later, Captain Bacon, who doesn't even work in the building that I stay in, he works across the street. He's responsible for the video program. He comes on my unit, asks the sergeant to open my cell and to search my cell. Doesn't even work there. I don't know how he just shows up. It's in the record. You can find it, not just saying stuff. Lo and behold, I then get infracted for paint missing in my room or something. Tear on the caulking. I don't remember what it was. So I get infracted. But of course they're not retaliatory. Of course not. They wouldn't do that here. They're too professional for that. When I ask the officers why it's necessary to strap me down, that it hurts to be straight on my back, they tell me I'm just doing what I'm told to do. I'm just doing what I'm told. It's funny, I'm a history buff. I really enjoy World War II history. I find it fascinating. And I've heard several times in the course of World War II history when they freed the concentration camps, and the officers who work at the concentration camps were questioned. Why did you do it? How could you do something horrible? How could you do something inhumane? You know what they would say? I was just doing what I was told. It's a great excuse in the history of the world. I'm just doing what I'm told. Pass on the buck to somebody else. Strangely enough, that's exactly what they said to the concentration camp workers. I'm just doing what I'm told. Dr. Stanfield, who's the mental health manager here at King County Jail, who's in charge, nominally, I suppose. Because of my lawyers, I have access to internal emails. On several occasions, he's asked the mental health person who's over me to change his wording in his reports, saying that calling my self-injury a suicide attempt should just be called self-injurious behavior, because then it makes it not sound so bad. It's just self-injurious behavior. It's not a suicide attempt. When he was on the stand in one of our court sessions here, was asked about me being admitted to Fairfax Hospital while I was out, asking why. He said it was for drug detox. That is absolutely not true. It was from a suicide attempt. My mom came home, and I agreed to go to Fairfax Hospital for mental health treatment. It was not because of just a drug problem. It was a suicide attempt. He called a lot of my suicide attempts suicidal gestures when he was in the courtroom. Suicidal gestures. You know, it's amazingly hard to kill yourself, emotionally and physically, when you bleed out slowly. It doesn't feel good, emotionally and physically. It's kind of hard to die. If that's a suicidal gesture, I apologize for it being hard to die. To me, I find him just another collaborator who's willing to work just for the system and say what he's told. He's just doing what he's told, just like the officers. The biggest collaborator of all, however, a good legal opponent, I'm sure my lawyer would add, is Nancy Balin, who was the defense attorney for the King County Jail. The ultimate collaborator, who in court compared me to a 14-year-old girl because I wasn't really harming myself to harm myself. I was just doing it like 14-year-old girls do it. She would often minimize my injuries, saying in the pictures that were brought to court, it's just a lot of blood. It just looks like a lot of blood. It's not very serious. She even said, you know how it is when you go and donate blood, you can bleed a lot. I find her the ultimate collaborator in this system. As opposed to just the officers, she's like the lawyer who defends the officers at the camps, say at Nuremberg. If you're familiar with the Nuremberg trials, you get that. That's all I have for my time and my stay here and my frustrations at being housed here at King County Jail. I wanted to speak to my family and to those who are harmed, but after hearing the disinformation that my family used, I don't really have the heart for it. And I'm sorry in this doesn't really seem to cut it. My aunt says she was upset that I used an Alford plea. I'm sure the prosecutor explained an Alford plea to her in his biased sense, saying that it was an admittance of guilt. That's not what an Alford plea is at all. The only reason I wanted to use an Alford plea is because I argue the premeditation. And because it drives the prosecutor insane. I have remorse, and I am sorry, whether my family chooses to believe it or not. I hope today by speaking they could get some of their angst and anger out at me. I hope it made them feel better. I'm sure they probably feel that I'll deserve everything that I have coming to me in prison for the rest of my life. I'm sure they feel I deserve to be strapped down to a board because, hey, he's just a murderer. It disgusts me that they've been influenced by the media that they even said isn't reliable. Who knows what the prosecutor told them? I just hope they don't believe everything they've heard. I want to speak briefly about my grandparents, whether anybody thinks I have a right to or not. There are few people in this world I love more than my grandparents. Truly. When my mom said that they were like second parents to me, she was absolutely correct. My grandfather was a second father to me after my parents got divorced when I was 16 and my dad moved away. My grandma could always be counted on to lift my spirits when having a bad day. My grandfather was always a man to look up to, not a drinker. Just throw that out there. Always gave me good advice on how to be a man. I can't believe my family would think that I would choose them. Choose drugs over them. I cannot believe that. Drugs had nothing to do with this. Nothing. I hope someday my family will forgive me. I hope someday I can forgive myself. But I see it as unlikely.
agree with the state that there is no possible sentence here other than life without parole. I don't think that even if it were possible for the court to consider mitigation, the defense has made out an adequate basis for doing so in this case. While I've certainly presented evidence that Mr. Boysen has suffered from traumatic head injury and that may have resulted in cognitive deficits, there's no attempt, nothing in the evidence before me that ties any cognitive deficits that Mr. Boysen suffers to any mitigating circumstances under the statute. The statute provides that the court can deviate down in sentencing when the defendant's capacity to appreciate the wrongfulness of his conduct or to conform his conduct to the requirements of the law was significantly impaired. There's nothing that indicates that any cognitive deficits that Mr. Boysen has an impact on those considerations under the statute, and therefore no factual basis for a mitigated or a deviation from the law, even if that were possible. So I'll sentence Mr. Boysen to 2 consecutive life terms without the possibility of parole. I'll impose the mandatory victim penalty assessment, DNA collection fee, any restitution that may be ordered. I'll also order, as indicated by the state, that there should be no telephone contact with Robert Taylor or Suzanne Campbell. Anything else I need to cover? Okay, thank you. Okay, thank you.
I'm also handing out a motion certification for an order of interest to
Okay. Okay, thank you. Okay, anything else we need to take up, counsel? No? Okay, thank you, counsel.
All right.